Hello and welcome to Domicile Corporate Services podcast series Advancing Vietnam with me, Vlad Savin and Matthew Lowry. Throughout the following episodes, we'll look into answering relevant questions about doing business in Vietnam. What are the opportunities and challenges faced by investors entering the market or existing players in major industries? We will seek to understand the business environment from a cultural local mindset and how to deal with compliance from an international perspective. What are the major risks faced by businesses active in the region and how to overcome them? And last but not least, we will dive deep into the compliance environment in Vietnam, discussing processes and procedures, changes in laws, latest official updates from the authorities, and financial governance planning for businesses active in Vietnam. In this episode, I'm discussing with Matthew Lowry, Managing Partner at Domicile Corporate Services, about labor and employment updates for Vietnamese companies and how employers can ensure they remain compliant with the changing laws and regulations, looking as well at new provisions for residency and work permits for foreign individuals based in Vietnam. Matthew, welcome to our fifth episode of Advanced in Vietnam podcast series. Glad to have you here.
Thank you, Vlad. Look forward to sharing more information updates on this particular topic, and particularly in this time of COVID, it's been a lot of changes and a lot of challenges, and it's always good to understand what is happening and what we can all do about it to stay compliant and understand the laws.
Indeed. Matthew, the new labor code was passed last year, coming into effect in January 2021. Can you give me a general overview on the main points companies need to be aware of? We will go through this in more detail thereafter.
Thanks, Vlad. Yeah, so the new Labour Code 2019, which comes into effect from 1 January 2021, so confusing as that is, the key part is 1 January 2021. So we've got a number of relatively minor changes throughout, but there's enough of them that makes a significant difference. One of the key ones is that the definition of an employee changes so that you can't simply use a service contract or other things to get out of labour law. It starts deeming the provision, effectively, the provision of labour, undertaking a job, receiving monetary payment and supervision of another party. Effectively, anyone providing labour will be caught under this law. So you can't work around it to get out of it and not have employee protection under the labour law. So it's much broader. Another thing that's done is introduce an extra public holiday. So we'll see that the National Day in 2021, not in 2020. There'll be one more day there. There's a provision for electronic labour contracts. So again, this is quite beneficial. We know now with COVID that the Vietnamese authorities are moving towards much more electronic interactions, less paper. We're still seeing the paper-based, but moving. This actually law has more consequences and understanding of the ability to do electronic labour contracts. Seasonal work, the seasonal contract has actually been removed. It doesn't exist anymore. Therefore, if you're dealing with someone on a seasonal basis, you need to consider, are you willing to give up one of your indefinite contract periods for that? And it's going to make some businesses a little bit more complicated to have to deal with their staff and a little more difficult, particularly those who do have seasonal work. Overtime hours, we saw overtime hours. We didn't see the total limit change, which was a lot of push, but we did see the monthly limit. So monthly's gone from 30 hours to 40 hours, but overall it's still 200 or 300 hours basically for most businesses. So that's something that a lot of people were wanting additional changes, but it still is a slight move in the right direction. Contract termination, there's a number of different contract termination, additional simplifications, generally to the employer's advantage, so that the employer is no longer as constrained. That said, it is still very much an employee-favoured labour law, and trying to terminate an individual is not a straightforward process for an employer. So we'll go through that and make sure that that's understood. I think later on we'll talk more about that in the details. Probation periods, there's a provision for an extended probation period for for management jobs up to 180 days. Again, we're waiting for guidance what that is, but at least the provision is there to that understands that you can't just have this generic cookie cutter version that has been applied before, which can constrain businesses. Your social insurance, moving towards a card-based system instead of these books and different things, a single card database. We've got that in law now that we're starting to move to it. So make sure that everyone's insurance and health insurance, social unemployment is linked through a single process and a card, which will be very useful. Work permit changes in work permits, particularly that there's now provision for foreign individuals in Vietnam married to Vietnamese to be exempted from work permit under certain requirements. There is the retirement age as well. So we see slow creeps up in retirement age as well. That's been a government policy for a while of moving up that to get the workforce working longer, and that's probably the key points coming out. There's a lot of information, but they're probably the key points, Vlad.
Let's go through the labor contracts first. How do they work in Vietnam, and what are the various elements we need to be aware of?
So the basis of a labor contract in Vietnam is that there's this concept of definite period and indefinite. So after 2 definite period contracts, employee becomes indefinite. There's no term. And that's important for the point of termination is very difficult in practice to terminate. And therefore, an indefinite contract, you need to be sure that that employee is the right employee. So you would do 2 definite period. Now that might be a 1 year and a 2 year. The 3rd contract would be indefinite. If after a contract period, you don't want to renew 15 days prior, you can tell the individual, I'm not going to renew that contract. The interesting thing is, so if you've got a definite period that expires, if you don't notify the employee that you're not going to terminate, or the employee doesn't, and you just continue, it is assumed they have the same contract that anyone else would get in their circumstances. There's an assumption in law. So by not informing that you're not extending or signing a definite period contract, you end up getting a new contract, which could be an indefinite if it's their 3rd contract. So you need to keep in mind that contracts are very date specific. And if you don't notify and the contract, you've actually got a 30-day period to negotiate, or they get the default. So that idea of definite period, indefinite, you can have up to 36 months for a periodic definite period contract. So you could do 36 indefinite. Not common, but is done. In my opinion, the 36 months does not, the probation process and terminating, it's very broad. So if you're not careful on recruitment and hiring and processes, that can be dangerous, having an initial employment contract of 36 months, but that's the law. We're built around this concept of indefinite and definite period contracts, and 2 definite, 1 then indefinite beyond that.
Just to clarify on this, so the authorities have removed the category of seasonal work, a specific labor contract with term under 12 months, and amended the definition of definite labor contract as a contract with a maximum term not exceeding 36 months, without setting a minimum threshold as well. So what type of contracts does the new labor law prescribe, and how should companies undertake them in order to be compliant?
Yeah, so the issue there is seasonal work has been removed. So in the past, you could do a seasonal contract, a short-term contract season, and every year do a seasonal contract. And they were not deemed as having a definite period contract, and therefore you could do it every year. And then workers wouldn't have the rights, but they had flexibility to go around and move around to do these seasonal contracts. That's been removed. This idea of using labour, just like I said at the start, where they've actually redefined and removed the idea of service contracts being outside the labour law, if it's for the provision of labour, the authorities want employees to be protected. So they've brought in this concept, removed the concept of seasonal work and said that is a contract. If you sign a contract less than 12 months, fine, that's one of those definite period contracts. Sign 2 of them, and the 3rd one becomes indefinite. Now, there is the issue, which I haven't seen clarification of is there a gap between them? How much time do you get? Does it lapse? And can you actually remove that automatic extension because you have not renewed? I believe there'll be some give and take there. But this idea that they are an employee, it's a definite period contract, and they're not because they're seasonal, a 3rd-class employee. They're still an employee with employee rights. So that should be also to be taken into account. And that 36 months has always been there, but they've also clarified that that's the maximum period. You could do a 1-week definite period contract. I don't know why you would. You can do 36 months. As I said before, I think 36 months on an initial contract is quite dangerous in some roles, given the difficulty in terminating should that employee not work out. But at the same time, it does maximize your ability to have a definite contract and not have an indefinite employee. With Gen X, Gen Y, millennials moving around jobs quite often, it may not be quite as important, but keep that in mind that there is some flexibility and some difficult decisions in an employment. What are the policies? What are the templates that you want to follow as an organisation?
And how does contract termination work under the new labour law, and what are the key differences compared with the old one?
Termination. One of the more difficult things, and also the harder to go through from an employer perspective. Employee can just give 30 days notice, or 45 if they're on an indefinite contract. Notice they're leaving. So the employee has it very easy. Termination from an employer requires quite a rigid process for notifying of breaches in the past on the current labour law, giving notifications over a 2-month period, a certain number of warnings, dealing with the trade union, dealing with labour authorities, and it is prone to mistakes, prone to errors. Very employee friendly, very difficult for employers to sort of historically to use. There is ability on restructuring things, but fundamentally it is this idea of warnings or people doing material damage to a company, etc. in the process. But the new law has introduced a few more provisions to make it easier, so broadened it. At the moment, if you've got a member of your trade union, you have to renew their contract. You cannot terminate them, and you cannot terminate them or not renew the contract. Under the new law, that's removed. A trade union representative is treated as a normal employee. They don't have special protection. And so that's been brought in to allow you to treat them normally and not be fearing that because they're trade union, they're untouchable. Retirement age people, you can now terminate them. They can leave. You can leave much more flexible to do that. If someone doesn't actually complete the work scope in the labour contract, and they've simplified this that it's in writing twice in 60 days. That's a simplification from the a minor warning, major warning system we've got at the moment. So in the new law, twice in 60 days, you can terminate. Now, unilaterally terminate, it still requires labour notification of trade union and authorities, but it's a simplified process. 60 days, 2 warnings. That makes it easier if they're not performing the task in the labour contract. So again, very specific, what's in there, what was defined, how do you document it, but it gives us a simplification. They've also introduced for the first time things like sexual harassment, maltreatment, coercive labour treatment. There is some provisions in there which are more legalistic, which were not there before, which give immediate grounds for dismissal. And it does require, again, trade union and other involvement, but it's immediate. It doesn't require this notification period. And so we need to see the detail behind. We're waiting on particular guidance later this year from the authorities of how they will require this to work. But we now have the ability in the law to understand that there are major issues that need to be treated with immediate effect. And so sexual harassment is one of those. The other one is also that foreign employees can be terminated on the work permit expiration, or if there's a court or something else that says they don't have capacity or have to leave Vietnam or they terminate. That's partly a new provision, but also it's the treatment where in the past the law, if you have a labour contract as a foreign employee, it's for 2 years, and is it automatically renewed if someone doesn't say it? Well, it may be. However, if the employer doesn't apply for a new work permit, do they have to? Are they required to? Can they not? There's a whole range of questions regarding work permits and labour law and how it interacts. So this law makes it clear that the employer has the ability to not renew, not apply for a work permit, and gives more flexibility to the employer and doesn't force. And it's basically removing contradictions in the law.
And under the current crisis, can employers unilaterally terminate labour contracts due to the pandemic? Or can salaries or benefits be reduced under current regulations?
So under current law and the new law are effectively the same. So the law states that you can't unilaterally terminate someone just because of a pandemic, force majeure, economic crisis. There are provisions. So there's 2 main provisions that exist in the labour law, the current labour law, Article 98 and Article 38. So 98 is this force majeure, pandemic, critical things, and that allows, subject to consent of the employee, employers to modify labour contracts, to reduce hours, reduce salaries, provided they pay, if they're paying salaries, no less than the regional minimum salary. So for for Ho Chi Minh City and Hanoi, that's effectively 4.2 million plus a certain allowance, but it's in that range. Or they can go leave without pay. However, that requires consent. It requires written document from the employee to say that they agree with the employer. If they don't consent, the employer cannot force that reduction. So that's Article 98 allows for variations. It allows for both parties to agree, and it requires consent. I see a lot of employees just accept it, employers there, which may come back to bite them, because without that consent, employers are not protected if the employee makes a claim against them later for not following their employment agreement. It's very important. If there is to be termination because of financial, economic difficulties, there is Article 38 allows a process for terminating. It requires an employment plan, restructuring plan. It goes to the trade union, goes to the authorities to show this is my workforce. These are the ones I no longer need because of economic difficulties, production lines, services not required. You have to show that you don't need those employees. And if you don't need employees, how are you going to re-offer jobs in other parts, how you're retraining, and you've got to put a plan in place to show that you've made efforts and that efforts are reasonable. With that plan, the trade union can object to it, but they can't stop the process. There is a process to involve them, and then the labour authorities. It takes 30 days to do that, then you've got to give 30 days notice, and then you can start paying out. There's a payout process for the individuals, and you can shorten that time with bringing forward payments. So that process can be expensive, but it protects the individuals. Now, keep in mind that employees do have unemployment insurance in Vietnam, so there is one thing. And this Article 38, going through the restructure and getting a formal approval for termination, is often the threat to say, if you don't agree under 98 to do mutual consent, to reduce salaries, look after us, everyone's sitting here suffering, let's do it together as a team, or we'll have to invoke termination. So it's often used as a negotiating technique. I can start termination, but I've got to do it en masse. Interesting thing is, under the current law, you can't terminate just one person. You could terminate two or more, but you can't do it to one. Under the new law, it does facilitate that if the restructuring results in one person losing a job, because you can reallocate jobs for everyone else but one, that's permitted. But under the current law, that's not permitted. So you can't just target an individual. So that's sort of where I would sort of describe it. It is about mutual consent or following a formal process, and you can't force things on individuals unless you are going through that very rigorous process.
There are changes in overtime hours as well. The authorities have increased the maximum overtime to 40 hours per month. Can you share some information on this subject and explain how the probation periods work under the new law?
Yes, so there was a lot of debate leading up to various variations and drafts in the labour law about increasing the number of overtime hours, and there was comparisons to other countries and requirements, and a lot of companies ignore the current things and employees want more hours. A lot of debate. What they settled on was to not change the total number of hours, which is in a year, which is generally 300 or 200 depending on sector, but to increase them monthly, to allow a bit more flexibility in the monthly maximum. So it was 30 hours per month. It's 4 hours per day, 10 hours a week. It's now 40 hours per month, not 30. So you could do a very busy week and do overtime every week, not every day. You could do some, but 10 hours a week, 40 hours a month. You can have those periods, but you have a maximum across the year. So the idea is, the authorities is, if it's constant overtime, you need to get your business structured to have more workforce and to have more shifts and not put the pressure on individuals. But we accept that during busy periods, you can work harder for those periods. And there's no perfect answer here. There's the employee looking after employee welfare, looking after demand, looking after some of those low-skilled employees in factories sometimes want more hours, want more work. So it is a give and take, and this was a really interesting discussion that the authorities and a lot of interaction with employers and employees and labour groups to get to this decision.
And what about the foreign employees? What do employers need to consider when they are seeking to employ foreign individuals?
The most important thing is that a foreign individual fundamentally must have a work permit before they can sign a labour contract, which puts the idea of probation and then I'll get you a work permit to sort of be not possible. There are some exceptions that people use under the current law, and under the new law they're clarified to really be not practical to use. And so this idea of getting work permits, getting the documents, then signing labour contracts. The second thing is that a labour contract cannot be longer than 2 years. So one of the changes I touched on earlier, but the idea is that it's a 2-year contract. You can renew it for 2 years, then you must apply for a new work permit, and if it's approved, you can sign another 2-year contract. There's no indefinite contracts for foreign employees. They're 2-year maximum. It's a 2-year, 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 2-year maximum for foreign employees. And that means that the work permit is a separate exercise to labour contract, but they're done in unison. This idea of employing someone on a business visa for a 12-month period under a service contract, etc., is not legal. It's not legal under the old law, but it was definitely removed any ability to argue anything like that under new laws. So employers need to make sure that they understand work permit, labour contracts hand in hand. Work permit first, within 5 days must sign a labour contract, and that becomes the relationship and how things work.
Speaking of work permits, the new labor law introduces a new category of work permit exemptions for foreign individuals residing in Vietnam and married to a Vietnamese citizen. Can you explain this and share more about how the work permit changes occur and should companies consider based on the new labor law?
Yes, so there were around about 17 or 19 exemptions under the old labour law and the various decrees with that. This is an additional category of work permit exemption. So just first of all, to clarify, a work permit exemption looks like a work permit. It walks like a work permit. It's just the application process differs. You still need a work permit or an exemption certificate before you sign a labour contract. So treat a work permit exemption as a work permit for a documentation purpose. It's how you get it. So a work permit requires a full application from the employer. Exemption is a simplified process, so you're exempt from a number of documents. In this case, the category introduced, as you mentioned, is that foreign individuals married to a Vietnamese are eligible for exemption. We haven't seen the decrees or implementing regulations. My expectation, understanding is this will require the foreign individual to have a temporary resident card through marriage to show that they are residing and registered at an address and they've been here a period of time, and they're not just visiting, they're not just having a temporary entrance to Vietnam, that they're actually here living long term and therefore would meet the requirements. So without having seen the implementing decrees, regulations, it's a bit hard to give the full instructions. But what it does, it gives a lot of, it removes some of the burdens on foreign employees that are here, understand the environment, have experience, but may not have a specific degree in a subject, which is a requirement for a work permit, a degree relevant for the role. If they may have a general degree, they may have something else, but the experience they've gained and the usefulness can be then used and employed in Vietnamese organisations. So they become more attractive to employers and not a burden to society and a burden in Vietnam. So I think that's a very smart thing to do. I think they'll be careful about how they implement it, but it will give it much wider opportunity to employ those who are legally residing long-term in Vietnam.
There are also changes for visas and temporary resident cards for foreign investors. What changes are happening now under the pandemic, and what should employees do in respect to these?
So at the moment, up until 1 July this year, because we also have new immigration laws, so investors are entitled at the moment to a temporary resident card for between 3 to 5 years as being an investor. So if you're an investor in a company, you can get temporary resident card for 3 to 5 years. And there's no limit. It's simply if you are named on the ERC, the Certificate of Incorporation, as an investor, so having contributed capital. The new law then now changes that. So from 1 July this year in 2020, you need to have approximately $130,000 invested to enable to get a temporary resident card. And that's a 2-year resident card. There are higher categories of investment to the point where you can get potentially up to a 10-year card if you have put a lot of money in as an individual. And so they've increased the ability to get a residence, but they've also made a lower category. So those who have less than $130,000 invested in capital will then only be eligible for a 12-month business visa, which can be renewed. That's not a working right, by the way. So the work permit exemption for an investor exists, and that still exists in law. We are expecting that the work permit exemption may also be tied in the implementing regulations to that $130,000 limit. It's not in the law, but we're expecting that because that's been part of the discussion. So if we now have the $130,000 limit for a work permit exemption because I'm an investor, that becomes interesting as well, where they have to apply as a normal work permit. and make sure they've got the qualifications. So that's made a much higher bar. What they're trying to do is stop people setting up companies just for the sake of getting around laws and using exemption categories at low value. And a lot of industries were using those sort of tools to get around those who didn't meet, foreign individuals who didn't meet the requirements and the experience and education requirements for Vietnam.
As you mentioned, the duration and provisions for temporary resident cards for foreign individuals are changed under the new law. Can you share a bit more about what are the new amendments according to the law on entry and exit?
Yeah, so individuals can have if they invest more than $130,000 US, they can have a 2-year up to 10 years. So there's a 2-year, there's a 5 years, a 3 year. There's a different categories, and that's pretty expensive because before we couldn't. Up to 10 years is significant to say you're a big investor, you're entitled. It also means under the law that for the first time, a foreign corporate investor can nominate an individual to receive a resident card as the representative of the foreign investor. And that's significant as well. There's always the foreign investor. Would someone come in on a business visa or something? It gives them a right to have a temporary residency to come in and out as they please. Now, I do understand that borders are currently closed, lads, so this is all discussion in theory about what's going to happen as things reopen up in the future, and it will open up for investors in the near term. There will be quarantines, etc., but we will see this coming into effect. So from an investment perspective, this is going to be important. And as people now try to access the opening up, they make sure they've got the right residence category, but including a corporate investor to say, I've got a temporary resident card and I've got a longer term right. So they've extended the terms, but they've also increased the limit so that small investors now don't satisfy, but large investors have a much broader range, and corporate investors can get temporary residence cards for a nominee. We haven't seen the specific regulations on how they're going to do this, but we don't expect to be much different than the current process of just documentation required.
Thank you, Matthew. And a final question to pull the information together. What are your key recommendations for investors operating in Vietnam in regard to labor and immigration issues, and where should they pay attention to remain compliant?
Yeah, so my few tips here, suggestions would be ignore this common process in Vietnam of using service contracts to get around labour laws. The new labour regulations absolutely stamp this out and means that you are going to be exposed. The authorities may not have really enforced in the past and issues, but it will be. So just focus on this idea of employment contracts. Seasonal workers have an employment contract. Foreign individuals get a work permit, have an employment contract, and just understand and respect the relationship. Insurances are payable, and they have been for a while on labour. You can't reduce the salaries, reduce your base salary to decrease insurances. It doesn't work like that. So just be compliant. Just do your labour contracts, declare properly, and just accept that that's where the law wants you to be. The other one is making sure you have internal regulations, develop those, lodge with the authorities, and your internal policies. Keep in mind that policies for operating can be separate to your internal regulations, which is your official labour processes, and your labour contracts, and they must all link together. If you've got something that doesn't match there, you're not going to be able to rely upon them if you've got a labour issue. And employers are at a disadvantage to employees, so make sure you've got those documents all together. And when it comes to smaller investors who have relied upon temporary resident cards and others, they need to reconsider where they apply before 30 June to renew everything, to get another 2 to 3 year period in the background, up to 5 years in the background, and so they're not exposed. But consider whether 1 July is a key date as a small investor you should be looking for. As an employer, just making sure that you are doing things compliantly with regards to contracts. There's one more tip we didn't touch on before, Vlad. There's one more thing. With regard to terminations, that if someone has lied on their CV or the application form, that can be used as grounds for dismissal for incorrect information provided to the employer. So another thing I would employers is keep those, keep the original CVs, and doing your annual reviews, just make note if there's been anything that comes up that shows that there was a potential lie or something material. The way the law is written, there's no backdate period for what that means and how long. It's a simple there. We haven't got the implementing decrees, but that's something to keep in mind. That may protect an employer if something happens to have that. And so don't just ignore that as an important part of your recruitment process. Keep that, file that, and monitor that, because that may be a get out for that wasn't in there in the past. So that's from 1 January next year. It becomes an avenue as well. So they're my tips and things to focus on for employers.
Thank you for sharing this information, Matthew, and your practical tips. Very useful.
Very welcome, and always enjoy having these discussions for the podcasts.
Understanding the employer's obligations in Vietnam is critical for maintaining compliance with the requirements released by the authorities. Companies should constantly be aware of the particular provisions regarding labor contracts, work permits, and immigration requirements, and always stay updated with the new changes, assuring compliance and minimizing any potential risks. Many thanks to you, our listeners, for tuning in to Advancing Vietnam podcast series. For more information about this topic, please check out our publications on domicilecs.com. And if you want to reach out to us for any additional details, feel free to contact myself or Matthew on LinkedIn or through the website contact details.